Good evening wherever you are, and good morning wherever you are. Then good afternoon wherever you are. Once more, I welcome you. Be Amra in the show GH. And then we chose only one topic. By Baba discuss it. Then you know in India, because of Ghana. Even by some finance, a Supreme Court ruling nearby, it's a politically motivated. Mostly decisions or judicial judgments be a baby, public no or more reaction. But we DMs too much. First time I'm at to say. The commander in chief of the Ghana Armed Forces are now doing an open part to ruling. This is the second time or the first time. The election petition or fine or accept it and issue statement on, but this particular one, so no, I can't want them. Now, I raise the issues be brave. You'll discuss it. You'll be focusing solely on this issue. I'm in charge of environment because there's a lot to say. The good old days. We have a lot to say. We have a lot to discuss. Issues be bria and a reason. A big global challenge Ghana Supreme Court, the jurisdiction. So bet me address this issue because it's a policy issue. We'll get into that issue. Yeah, we are. You been offense or Bob divided into two. We talk about the judicial aspect of it. Then we talk about the political aspect of it. And then offer half of the time. Not intro, Mr. Maya intro, with the judicial elements, But on this note, whatever we are saying here, it's not legal advice. It doesn't bind anyone. It's our stated opinion based on our court arriving at the decision and what is within the public domain. And I ever discuss it. Mostly judicial decisions and most of the times in the logic and the interpretation. But with it seems as a public now taking a walk. There's so much chaos, not even within, not only even within the ordinary people, but in the field of the academia, there is a lot that is going on over there. So now, the summary of the whole thing. This is what is happening, or this is what has happened. Now, most people are saying the decision that was made on November 30th. And already in say parliament has been divided into two. It's been divided between the NDC having 137, MPP also having 137. Okay, so with one independent candidate for MENA MP So at this point, say koto abana say Pepe 137, which balance and it was minus Adwasafua. So that MP gets in. So Omu voti abano. That time Backman wasn't there, which is the Speaker of Parliament wasn't there. The Deputy Speaker, Joe Wise, is sitting in. Or sitting in, and according to them, the Constitution was silent about it. So he counted himself to be part of Nipana Etuabano. And what happened next? About they can approve the E-Levy. So I had this back and forth with these issues, There's a lot of premises on it. Then the issue went to Ghana, MPP or the majority side, if I should put it. They took the issue to Ghana Supreme Court. Now I'm call Ghana Supreme Court, put issues in a court and narrow issues into three issues based on what the plaintiff need. Now the court episode changing and say now all finding out say whether or not a deputy speaker or a member can be part of quorum formation. That's one. Two, whether or not the deputy speaker or any other member can also exercise the right of vote. Then the third issue was about the decision on one arrive at conclusion. Say, you bet to me a hodiana. See, hodidia. Now the court is saying, say, you're passing E-Levy. Is that what the court is saying? That is where I have an issue with. The first issue, the second issue, the third issue, I don't have any. First and second, fine, we'll discuss that. But the third issue, the one problem. Now, there's also another issue about jurisdiction. So let me start it from there before we get into the whole thing. When you talk about jurisdiction, simply what the court is trying to say, or what it means, once a court be to me or any issues or with me addressing. So your murder case will want to me appear before civil court, unless I will challenge the civil aspect of it. But to challenge, or your some cases when it comes to constitutional interpretation, it cannot be challenged in any of the lower courts, even unless jurisdiction on the highest or the apex court is the appellate court before somebody can address the constitutional issues. Other than that, all constitutional issues must go to the highest court in that jurisdiction or in that country. Let's put it that way. For instance, state of Massachusetts, who person will seek constitutional interpretation, you go straight to the Massachusetts Supreme Court. When you go to the state of New York, almost judicial settings, it differ kakra, but that's not the only state. Almost highest court is the appellate court. So, any constitutional issue, you don't go to the Supreme Court. I don't want this to raise any confusion. You go straight to the highest court, which is the appellate division of the New York Court or the appeals court of New York. Okay, about 80 to 90% of jurisdictions, almost highest court is mostly called the Supreme Court. Few states and then narrow say, like New York is a typical example. Appeals court in the that is how almost settings here. Now let's take Ghana. When you go to Ghana, their main issue, their high court, the apex of almost judicial structure is their Supreme Court. In their honor, say unya asem na say person will challenge you to the highest, you go to the Supreme Court, or afterwards you do what you call review. The review itself is even done at the apex court, which is the Supreme Court. So now, this issue being a constitutional issue, they took it. I want to file a case on behalf of MPP. I'm going to take a case straight to the Supreme Court with the motive to seek interpretation of Article 102 and 104, including Standing Order 109. So that's what we are going to talk about. These are the authorities, Ghana Supreme Court agent also Eddie ruling a buyer. But you know who public in reaction. It's very unfortunate since you see judiciary the ruling be bar as a your critical partner mom. Or I don't know, say this particular judiciary it's like they've been too consistent with their ruling and the court become very predictable. I don't know I main issue Ghana phone be problem with what we are seeing or what we are going through. But other than that, honestly, we don't see anything wrong, say court Eddie ruling ebeba. But issues now a court on and how court conclude anyhow public are reacting. Who said the president of Ghana while responding to this. The former vice president, John Dramani Mahama, His Excellency, also responding to it. And MPP, MPAB for saying are responding to any issue, I'm court and inviting. It's nowhere to be found. These are some of the issues that happens. Now, most academicians, certain politicians, certain people from the academia also responding to this ruling. But you see, my main concern is court decision on making in regards to November 30th decision on making. That aspect now court the best what I say. Lord Dami, I heard him saying because a court a strike order 109 so it implies or it affirms the decision they made on November 30th that I have a problem with. Because you want to make it law emanating retrospective effect. Meaning, see, not law be that was say, ubi kunipa yenyanishia. Now, that is maybe running a law or ubi kunipa yenyanishia. How want to mean ko pass a law echana na me kase ubi kunipa since yes sense our law say ubi kunipa ubi ko jail nti no say ubi kunipa and rent me be fast our law na dia ayeno no say indeed you hold the Supreme Court judgment now my understanding about the application of the law It should be said, therefore, and I'm go back, no more than go to Abani or Ghana's parliament. So I'm to Abana near my presiding speaker now, Tim Sisiana, which is Joe Wise or Joe Asewusu Etnem Erulia Etnemubia. He will be counted. Because Supreme Court ruling now make it take effect as at Wednesday. So I don't see why the Attorney General is trying to establish the fact say a hold and the court itself in their ruling. I know say reasons and then by, but the ruling very well. It's like they are enforcing the November 30th decision. If my understanding is right, this is how I got out of it. I don't know how I'll be so epic, but you're beginning chronologically. If you are now for the remaining time, you're looking at the political aspect of it, I mean, me wasting so much time on this. I don't say more young corner stages. So it actually started from here, Ghana's parliament.
The court answered that question yes, indicating that the deputy speaker can be counted when
with this report.
Two main issues engaged the attention of the judges. The first had to do with whether or not the deputy speaker can be counted as part of quorum formation for parliamentary decision making. The court answered that question yes, indicating that the deputy speaker can be counted when a quorum is to be formed for parliamentary decision making. The second issue has to do with whether or not the deputy speaker can vote in terms of a decision-making process in Parliament. The court said that whether presiding or not, he retains his right to vote. Therefore, the court concluded that the approval of the 2022 budget on November 30, 2021 is valid. The Attorney General Godfrey Adame says he expects Parliament to abide by this decision, and the chaotic scenes that marred the parliamentary procedure will be a thing of the past.
The reason by the Supreme Court clearly is sound, is in accord with the practice in other jurisdictions around the world, and also clearly borne out by the letter and spirit of relevant provisions of the Constitution.
This applies to forming of quorum for business as well?
Yes, because indeed the Constitution itself was quite clear. Whenever it seeks to exclude a member presiding, it says so clearly. So you see that for the commencement of business, ordinary business in Parliament, it says with the exception of the person presiding. But such exception is not made in the case of forum for decision making. So when it comes to forum for decision making, the member presiding, if he's a member of Parliament, clearly will be included in the record of the quorum.
In terms of subsequent parliamentary business, I mean, as Minister for Justice, you expect that this will resolve the matter and avoid the scenes that we saw when the deputy speaker attempted to vote previously?
Oh, yeah, definitely, yes. I mean, those scenes clearly were needless and were really inspired by mischief, because all those mischief makers should have known that the practice in other traditions, whenever the person presiding is a member of Parliament, that person is not precluded from exercising his right to vote, exists. So I think those scenes of Parliament were really unwarranted, and we really hope that they will not be repeated again. The Supreme Court has brought clarity on the matter, and it should guide the nation going forward.
Private legal practitioner Justice Abdullahi, who filed this case, has been reacting as well.
There are only two outcomes. It's not like a football game where there'll be a draw. There will either be a win or a lose. But in this case, I think there's actually no one lost, because I think the Constitution wins, the people of Ghana win, and this is the best decision that I think we should have had. It puts clarity on the law, but despite the fact that some of the reliefs that I was seeking were not obtained. But there's a far-reaching decision that has been made by the Supreme Court today, to the extent of striking out portions of the standing orders, and this is very good for all of us. It puts clarity on the rules of Parliament, and indeed it makes all of us citizens. And I think I would probably use this opportunity to invite all of us to be participants in the democratic credentials of this country. We all have to play our roles to ensure that we get the best outcomes of our constitutions. This is just one of the things that we'll be doing going forward to ensure that the difficult decisions in bringing the sort of cases to the Supreme Court for clarity to be put on some of the issues that borders on sometimes illegality are all put to the past.
It is not clear whether government will send the E-Levy bill to Parliament anytime soon, but it has been one issue that has been thorny in the last couple of months. For joining us from the Supreme Court, my name is Joseph.
All right, just ended was the actual report court issue here. Let's get this also.
Article 1041 of the 1992 Constitution. He thus wanted the Supreme Court to declare that the decision taken on 30th November 2021 to approve government 2022 budget amounts to a nullity and is of no effect. The 7-member Supreme Court, however, held that a member speaker is entitled to be counted for purposes of quorum for doing business and to vote in business of the House, even while presiding. The Attorney General and Minister for Justice, Godfrey Adame, said the interpretation placed on the provision was simple and straightforward.
It's quite simple and straightforward. I perceive the issues as very simple and straightforward because nowhere in the Constitution has any statement been made that whenever a deputy speaker presides, he loses his right to vote. Indeed, as I indicated in the submissions for the court, all the circumstances under which a member of parliament will lose his right to vote have actually been spelled out in Article 104 itself. And so it is really void of controversy. And it's also very important to know that in all jurisdictions around the world, whenever the Speaker of Parliament or a Deputy Speaker of Parliament is a member of Parliament, he always has the right to vote. In England, it's the same. In America, it's the same. In Australia, Canada, everywhere is the same. In Kenya, even in Africa, Kenya, South Africa is also the same. Whenever the Speaker of Parliament or Deputy Speaker of Parliament is an MP, he never loses the right to vote. The right to vote is actually linked to the right to represent his constituency. Are we saying that on account of the person being a Deputy Speaker, he loses the right to represent his people when a major issue of national importance has arisen? I think the reason by the Supreme Court clearly is sound, is in accord with the practice in other jurisdictions around the world, and also clearly borne out by the letter and spirit of relevant constitutions.
And this applies to forming of quorum for business as well?
Yes, yes, because indeed the Constitution was quite clear. Whenever it seeks to exclude a member presiding, it says so clearly. So you see that for the commencement of business, ordinary business in Parliament, it says with the exception of the person presiding, but such exception is not made in the case of forum for decision making. So when it comes to forum for decision making, the member presiding, if he's a member of Parliament, clearly will be included.
I mean, in terms of subsequent parliamentary business, I mean, as Minister for Justice, you expect that this will resolve the matter and avoid the scenes that we saw when the Deputy Speaker attempted to vote previously?
Oh, yeah, definitely, yes. I mean, those scenes clearly were needless and were really inspired by mischief, because all those mischief makers should have known that the practice in other traditions, whenever the person presiding is a member of Parliament, that person is not precluded from exercising his right to vote. As this. So I think those scenes of Parliament were really unwarranted, and we really hope that it will not be repeated again. The Supreme Court has brought clarity on the matter and should guide the nation going forward.
For the applicant, Justice Abdullahi, the Supreme Court's...
Sure. Just ended again was the Attorney General of Republic of Ghana, Lawyer Adame. Interpretation of because you see, look, this is how, if you take it from the plaintiff, lawyers now file issue, on behalf of NDC and those that open defense, which is the Attorney General on behalf of MPP or majority in Parliament. Clearly, this is what the court came. This is the conclusion of the court. From my understanding, so I'm observing it very well. Not per se, I'm taking a stand to make a judgment. You see, with the application of law, sometimes you can't make law to cover all aspects of human life. Okay, so here there was a gray area, and that's what the court actually, or that's what the defendants, which is lawyer Odame and team they're filing on behalf of MPP. That's what they did. They capitalized on that gray area. So the 1992 Constitution, and in denying Deputy Speaker, so sitting in as a presiding speaker, or taking that position now, in denying on the right to vote, neither does it deny him the membership to be part of the quorum formation. So at this point, it's gray. That's where we say court need to use the discretion. But we say to sound very persuasive, make your argument be. Or even when you go to certain jurisdictions like United States, Britain and Co., no cite examples say there are some people there are some members of parliament or deputies almost sitting in for cases that they still have their membership right to vote. And also to be part of quorum formation. Quorum meaning, I said, the number that we need to bring an issue before the House. So that's what Lord Adamo was trying to tell us here. I mean, you see, we may not be able to force so much on those external authorities. I mean, it's not applicable, but it's just a persuasive. Yeah, a Supreme Court ruling, so TB, our ruling are there. So it can happen that way, but my main issue right now is, I mean, you see, in as much as how you target your court system, no, excuse me to say, I mean, after response, no better be. Say court is being biased on certain issues. I mean, all over the world, ruling be in California, court, no. But say you be deviated from your standard of reasoning, mostly based on your politics. Because Ghana, it's like we have two standard of reasoning, either the MPP stream or the NDC stream. Looking at this, no, I think Odami and his team did very well because it's clear. If there's no law stopping something, therefore, the person is entitled to do it. And as I stated earlier, so you need to mean your law be to cover all aspects of human life. No? But one thing I'm looking into, you see, all these things are technicalities. I think the lawyers reason very well. And now you're going into some of the reactions are a buyer. Okay, Mamin Koti Adiebu, it was very unfortunate. I mean, this is what they said. A 30-year-old rule in Ghana's parliament has been deemed unconstitutional, thereby giving space to Deputy Speaker to vote on key decisions, particularly the government's proposed tax on electronic transactions that has divided the House for months. You see, when we talk about law, or if we really want to go into the definition of forms of government, how the judiciary should function, the executive and the legislature, it's very clear here. So Supreme Court, have power to quash any authority. Yes, they themselves can even make law today, and the following overrule that law and make new law. So I, as a person, have no problem with what the court has done. But I don't know, since I haven't got a full report, the court makes a November 30th decision in the year, or confirming you find applicable there. That I have a big problem with the court. And that's what Lawyer Adamo is trying to say, if I understood exactly what he was trying to put out there. Because that would be a retrospective, like, or a retro of the law. Law now, you're passing, as I say, no pass it, and I mean, I say if I want to bind it, past event. It doesn't work that way. It does not work that way. That issue I have a problem with him. But the first ruling, the second ruling, I think say court and capitalized on the gray area based on what the defendants and the presentee. But if anything, now the court has given the order that the deputy speaker does not lose the right to be part of quorum formation. And if I can form a quorum, definitely I should be able to have a right to vote. If that is the case, then I'm going to call for new parliament. No more vote. So I'm vote here. The deputy speaker now vote and will be counted. Therefore, we'll give MPP the right to pass the E-Levy. Now, I'll show some of the response. I don't know how to respond. Former President John Dramani Mahama also responded. A.B. Fuseni, one and only, also responded. I was saying, I got into trouble, issues that have to do with contempt, because he also targeted to be like a political decision. And I listened to Harry Naidrusu. Harry Naidrusu and co, they are only looking at the political aspect to discuss this issue. That is the danger. Because irrespective of how bad the policy is, E-Levy, I personally, I don't support it. I have a big problem with it. I see it as a double taxing. I say, taxing individuals, double. And two, in a way, they are trying to kill electronic transactions. So maybe the 50,000 mission bottom now won't tax me E-Levy on that. That's what be a bank transaction. That's what the tax now. That's my common economic basic economics 101. Simple. I mean, in a way, crime robbery and mobile nasa doors would be two. No, but discouraging for some big good businesses, no. So I have a big problem with Saudi and Kasa Air Cost, no. But not per se is that the legal aspect of it, We use political understanding or how bad the issue is. Now they are a persuasive argument. No. The application of law will always supersede your opinion and your political authority. That is what we should understand here. So at this point, I think the court did not err at all. But I'm yet to find out about the third ruling. So I'm going to say November 30th November decision on make here. I take effect. I heard there is a big issue. Court and can do that. In no jurisdiction on this earth can do that. But that's the Supreme Court in the they are exceeding their tentacles. They are going beyond what they've been mandated to do. Now, the issue about jurisdiction, I explained earlier, or I stated earlier on. So, what say court to be the jurisdiction over issuer means our power to hear a particular case or adjudicate that case. And here's the case, you see, mostly, okay, no matter how powerful the court system is, all over the world, per my understanding and little experience, I can say that court to be will be to address a policy issue. Because per the forms of government, policy issues are located to the other arms of the government. We talk about the executive and the legislative body. The executive body, being the president, the ministers, the deputies, the CEOs, and those authorities in charge of delegations under the executive arms. They initiate policies, they implement policies. And one main officer they're in charge of policy issues and Kasapaya, parliament, which is the legislative body. But here they didn't go to court to address a policy issue. They challenged misunderstanding of a law surrounding a policy so you should be able to distinguish between the two. They didn't go to court to tell the court, say whether I say E-Levy, papa and I say papa. With that, the court doesn't have, and the court will not have jurisdiction to interpret that. But they went to court to challenge laws in terms of one's membership, where quorum formation is concerned, and one's membership of right to vote or not to vote. And now the third issue, initial decision on making November 30th November 2021. And no second so by uphold here. So we tell you damn very well. Let's see what the court will come up with, the reporting. If that is the case, it's almost a convening parliament to be no vote issue. Because our law need to take effect as at Wednesday are ruling a binding the entire nation. So that's what it is. Now, share some of the response from the president of Ghana. Yeah, current president of Ghana. Yeah, Nana Addo Dankwa Akufo-Addo. This is what he said.
Now I become president. Every time there's a constitutional matter, I'm here to pronounce on it. It will give the impression that I'm setting myself up as some sort of rival Supreme Court. And I've been very reluctant to do that for that reason. The body that the Constitution has set up to be responsible for declaring the meaning of the Constitution, interpreting and enforcing it, is the Supreme Court, is the judiciary, with the Supreme Court at its apex. And as a matter of good governance, it's better that that body, which has been given this exclusive power, is the one that is heard on constitutional issues. And that's the reason why I've not been open or vocal on constitution. But I think this one, I feel strongly that I should make some comment. First of all, the noise that was generated for this, at the time I was extremely surprised because as far as I can see, and I think the Supreme Court has confirmed it, the matters involved in this thing are open and shut. They're black and white. There can be no dispute about the issues that the gentleman took to the Supreme Court. It is there for anybody who wants to see. In Articles 102, Articles 104 of the Constitution makes it absolutely clear in black and white.
All right, let's see. This was a response of Nana Addo Dankwa to him. Said there was no need, Grandpa said, the lawyer not representing NDC for no yes idea because the issues were very. To him, there wasn't any ambiguity for you to go to court to seek clarification because they were very clear in its nature. That's what he's trying to tell us. All right. Now, Yenshe, what also happened aside that? The former president of Republic of Ghana, John Dramani Mahama, also the response in it. Okay? I'm going to take time to read it. I'll say, that was his response, ruling by it. I'll say, if Deputy Speaker, because they are members of Parliament, can vote while presiding as a Speaker, they could as well be able to participate in any debate on the floor over which they are presiding. This is absurdity into which the Supreme Court ruling leads us. Interesting. Kamina Obi hosting I say no comment. And minim say we are movie bring opportunity to follow Gabi. Or say mom and fan channel because we need background in law. It's something we should forgive this man. Okay. This one Gabi or Ochidako Kai. But I say Abansumani back in there, we shouldn't forgive him. Okay. No, this 7-member panel normal for me, Justice Doche and Etenazo said the approval of the budget was valid when the Deputy Speaker Joe Osei-Wusu voted while he was presiding over affairs in the chamber. Private legal practitioner and a law lecturer Justice Abdullah, subsequent to the November 30th, 2021 clash between the Speaker Bagman and his first deputy after later overturned an earlier vote of the House rejecting government 2022 budget, invited the Supreme Court to pronounce as unconstitutional Deputy Speaker Joe Wise's action of counting himself for the purpose of the quorum. He argued in the context of 102 and 104 of the 1992 Constitution that the Deputy Speaker was not permitted to count himself for the purpose of quorum, since he had neither an original nor casting vote as a speaker presiding. The Supreme Court struck out the Standing Order 109, Section 3, which says a Deputy Speaker or any other member presiding shall not retain his original vote while presiding. It further that the Deputy Speaker can be counted during the quorum for decision making according to Article 104. This is what happened. On say utie Justice Doche report na. Obaso chesa adena Joe Wise etna so no as a Deputy Speaker or sitting him Honorable Bagman, no, which is the Speaker of Parliament. No. There's no fault with that. Only be any. Presiding over the affairs in the chamber. I say because the budget was valid. If it is valid, then there's no need for us to go form another thing. But you see, we are waiting for the court report. No? Mostly, it's a court coming out with certain decisions. I hold will explain further, need to arrive at and further instructions. If that's the case, there's no need to form new, convey Parliament as I go to a banning bill. Means I take effectively. And what I mean, no more problem. That's like retrospective. Like I have explained earlier on. Pass law now, it takes effect from today onwards. Pass law now if I'm going to combine it after the facts decision as MBSC, that is absolutely wrong. That is unacceptable. No judicial system any accept it at the end. How Justice Doche was trying to imply here, but let's see in subsequent weeks ahead of us now. Then share how la interpretate it and that's some report on the web. Now, this will happen with some of the NDC for leading members. Harun Edrusi is a lawyer. I'll say, after the ruling, Harun Edrusi stated that the ruling by the Apex Court is judicial support for E-Levy and nothing more. Judicial support for struggling economy in distress and a judicial support for restoration of matter that they have said is constitutional. Is what? I'll say it's repugnant to the provision of Article 102 and 104. He maintained that this is a travesty of parliamentary justice and step in the growth and development of multi-party constitutional democracy built on the spirit of checks and balances. So what are the two paragraphs now here now? on far legal authority be and challenge what the Supreme Court has done. Okay, but what Haruna what Haruna is just and is saying political talks based on the opinions and how bad the economy is and how desperate this party wants to bring another issue to curb the people. I don't know how to argue on. So that is where the problem is. So in short, conclusion per my understanding, the Ghana Supreme Court actually ruling this to favor the defendants and all, or Dami and his team, no, it's because they capitalize on a gray area. Mrebian where said deputy speaker no want to be into about for me quorum you have a membership to vote. Simple as that. Simple as that. Idea with it very simple. Now let's look into the political aspect of it. No? So there's a gentleman the be any issue offer. I mean try say and ibinya offer na omwa kakra. Yes, over.
Yes, sir.
Good evening, wherever you are. Let's say. And then him say, colleagues, you know, may notice him say, attending to certain another important program into me and joining in there. But and then you see just idea so you are aware what is happening in Ghana across the BBR on himself. I bet check background. Yeah, welcome, you know. You get to the political aspect of the whole thing. No? You be a very quick, quick commercial. You hear no? You hear no? Now. All right, offer. Hello.
Yeah, no,
yes, let's do this. And the next 11 minutes.
Now we almost to me show no so
I'm so attending to some programs, but are sure as next week. But then not yet stick with just one topic there because I deal with how ruling we by area. I divided public into too much. We share even those from the field of academia. No, more. But it seems as a party in Ghana, as a judiciary has become very predictable. It seems. But you see, it's not always the case. You say a target judiciary or that man in that manner, no. Because you know, ruling me name say uti analysis na me play the plaintiff side and the defendant side. From my understanding, I think we say court no ruling no on behalf of the defendants, which is lawyer dominant and Crawford a present issue no. The court no they did what the lawyers did by showing the gray area. Gray area means law BNY binding. Therefore, court now is giving that authority to exercise in discretion. Because a BNY stoppage Joe Wise, and this is a standing order. And to me, these are some of the challenges in democracy. Okay, this are some solution. For it's been 30 years, and as our other way, and but one thing we should all understand is the Supreme Court has no power. Indeed, they do have power to override articles, statutes, laws, bylaws, ordinances, and this is a standing order in Parliament 109, and the Ghana Supreme Court is almost questionable, meaning almost uphold 102 and 104. In that respect, you know, maybe only problem I had with the ruling is say, almost to me, say November 30th at the November 30th decision now, Joe Wise, Honorable Joe Wise, transnational, young hoodie, and it almost yes a retrospection of the law. Almost as a Marana, Masha Marana, and film say binding and after the fact they can't do that. But almost will convey Parliament. Now, if you Joe Wise into it, that will make more sense and will have more legal or judicial basis. Now, Harry Nadusu, a question decision, you know. Also former president, His Excellency John Dramani Mahama, or say tantamount to absurdity. That is how the Supreme Court has led us. Now, other people also are responding. I'm a ABA for saying the so called Kamana Kabroso. Now, for the next 9 minutes in the mouth, the political aspect, you know, what do you think about it?
Okay. Thank you very much. In fact, like you were saying, actually, my dear commentary, but me myself listening to the ruling and then reading the verdict, you know, and then listening to some commentators near what they are saying. Actually, now, what you are saying, it is now becoming very clear in our country that you know when at the end we are to aswa a do baby and not say what they are saying. Acquire say this kind of the current Supreme Court ruling is tilting towards the ruling government. Acquire say like Semrebu Kaya, one who said the former director of the law school, or can I say most of the time the judges, you know, when they are appointed to do something, they rule in favor of the government, the one who appointed them to be there.
Oh, I read that. And now Raymond to begin so your research before I don't know. Yes.
Very good. According said they have to praise their masters or the one who appointed them. Sadly, I must follow Mama who say because in Abacha, in the first place, there are two things. Supreme Court, just said. I don't mean like this. I don't believe in it. There is nothing that Supreme Court will bring that I will follow. And then you know something too. You can easily predict them now. Any case that will go to the Supreme Court, provided it is even ASL government related idea into it, you know, you can easily predict their verdict. Verdict on them, but you can predict it, and you'll be right. What you are saying? No one will leave so they rule and they don't care. About number one, maybe more about. Look at the first time we hear
best set,
very good. The best Abacha, and you are killing the spirit in them, and can you start for me sometimes and say, well, let's give them the benefit of the doubt. But that birth certificate no must be fully Abacha. Birth certificate is not the primary document that actually should be a citizen. Up to now, I don't understand what they are saying because Abacha, America, high. And even there is no country in this world where you go and they will come in a Supreme Court, any court, or anything in that country can tell you, say, birth certificate and yet a primary document of citizenship. Anybody except Ghana. Even Ghana, before, it wasn't like that. And that this just this regime. What they are saying. And you know why? They did that because they saw that the EC was going to kick against that. So they want to do something that will favor the EC so that the EC will be able to rule out that. So what they are saying. And when the moment will pass that judgment because they want to favor the EC and because the EC is in the side of the government and they are also in the side of the government. Have you said it? If you say I get the time, only me here the officer or every government. Judgment is no you. If you say you told birth certificate, only here you must say and your primary document for someone to become it. Which is false. What they are saying. And you know, some we Abacha, we near my city, not public in the ceremony. Because we have not been to the law school, court of public opinion. What are you talking about? Law is the interpretation of common sense. It is that way that because you have the power. You have the power. We know. whatever you bring out, we have to accept it. And Abacha just had it. When the Supreme Court has spoken, we have to take it. But it doesn't mean to say, you need to have any pita about that day, pita, and what the country say to me and to say. Yes, sir, we don't trust you no more. So what they are saying, and no. When somebody can you tell me, say, all the election 2020 Supreme Court cases, 7 if one in a ruling, unanimous.
Yeah,
what are you talking about? Are you telling me that all that church was saying there was nonsense? Abba.
But of our own, I know, sir, looking at the abet set and the Supreme Court ruling, the election petition, I know, sir, a lot of people have their reservation, including me and MTA, okay? Including other people from the legal field, you know. Lawyers will be criticizing, say, civil issue there. Civil issue, they will be try civil issues, so many 7 interrogatories. It's never done anywhere. And then the anti-Supreme Court and I say up to date. But with this particular ruling there, you see, and I want to mention you so be past issue, they be predicting the present or future actions. It can sometimes. But what is a particular issue, Supreme Court and coming to that ruling, you know. I think Odame did a good job, and the court also honored them with that gray area.
Yeah. Looking at Mami, this particular one. As we are saying, you know, I was just giving you instances in Yamabi or Maya, HSA, this one is hard. And if you look at this particular ruling now, you also see 102, no, a catch says this and this, you know, they can't vote near what they are saying, which is not in the constitution, but they have it in their standing orders in parliament. And I will also know that Article 110, right, is 110 that allows the parliament to have their own way of regulating their business. And see, if they have this, and we all know, speaker or only vote, because we are supposed to be neutral, who preside over a neutral. And now will be a deputy speaker. Once you are deputy speaker, automatically you assume the role of a speaker. So what they are saying, if whatever the speaker does, you can also do it. And besides, though it's not in the constitution like that, they can Supreme Court can amend it. Do you know why they are doing this? They are entitled to bring this law and amend it whatsoever. Let me call it that way. Amend it because there is a particular issue, a bone of contention in Parliament, of which they are bent. They think that if they do this, E-Levy may have a chance of getting passed. What they are saying. And looking at what look at how they rule about that. Telling us that some of my deputy speakers now they will disenfranchise their people. And constitution to know Muslim, just said they are disenfranchising them. Let me ask this simple question. Is it not the same Supreme Court and a ruling against the people of SAR by not giving them a
representation in Parliament? Yeah, but I know that this references, some instances really now about the case we did, Mr. Japan analyze issue. We are see.
I've taken my time to go into this matter, like you are saying. And if you like, I'm saying, if you follow what I'm saying now.
No, me follow. I know you are proving consistency, but that's what I'm trying to say. It's not always the case. And to me, I depend. You see, be the consistency issue. What I say, like how was your behavior in the past? Yeah, they determine the action. That's what I'm saying.
And you know, in the world about that. This ruling came out simply because they know that if they do it like that now, it will aid them so that the E-Levy can be passed. It's where they name the E-Levy verdict. It is an E-Levy verdict because they know that when they sit in the Joe White chamber, and look at what the president said. The president said Parliament is not above the law. We also said the 3 arms of government in America, none of them is above the law, right? The executive is not above the law. Legislature is not above the law. and the judiciary, you are also not above the law. That is why there is check and balance. There should be check and balance. Obi and you also saw a powerful tell the other. So if Parliament have the rule, and I don't know Constitution 110, it says that Parliament have they can make their own decision and regulate their procedures in Parliament. Why do you now come from the judiciary to come and tell them that the Omodiasha honor the Sadia way to say and even look at what they are saying about that. They have taken it out. So the Chief Justice no. Governor Dami should go to Parliament now and sit down with the parliamentarians, and then now they have now sit down to write a new standing order that will allow what we call it Joe White and the deputy to vote, have a vote. Mu pass a verdict. Now Odami should now go and sit with them and then tell them come that they should write a new standing order. Look at that. In one way or the other, I don't know bring you confusion about that.
Yeah, we saw more questions. Because of be a strike, it's been struck down in the sense that Omojisa 109 every. But problem I mean no more want say. And Wednesday the muyi most strike most Wednesday and the Supreme Court struck the 109 article standing order 109. Yeah. So it means it should take effect from Wednesday coming. Wednesday and its future, which is Thursday, Friday, Saturday, Sunday, Monday, and up going forward. Omun to mean Kase November decision no make you know. So that decision now Supreme Court making Wednesday binding no any day. Yeah, what I mean no more problem no. Did we hear the report now? The person say Joe White sitting in it wasn't unconstitutional. Like there was nothing wrong for him doing that. Yes, there was nothing wrong, but that time now the law hasn't been challenged. It is say oba enaka man strike 109 there and what Justice Doche was saying is right. But to be very principled and legal here, what I believe in is court rather we are waiting for the instructions and consequential orders from the court. That will tell us what the parliament is going to do.
Okay. In the fact, Abaja, the fact is that under this current political dispensation, that's the Fourth Republic, we are about 30 years now, right? Mm-hmm. And I used to you almost standing on the Juma and Rollins 1 and 2, 4 1 and 2, Mills, Mahama, and now. Why is it that after the moment who said Sadia will win? Is it not because of the controversial E-Levy?
I know, but over all the laws there. Over laws there, Yana. One thing I mentioned, because the laws there is subject to interpretation. So
it's subject to interpretation, and we know it can be amended. Mm-hmm. But what we are trying to talk about today, the main thing, the bone of contention that everybody will be looking into it.
Oh yes, yes. I send me the coffee. Send me by offer.
So when I make a man name E-Levy.
All right, offer. The angel is saying. Yeah, the back next week, me boy. To my final words now in Jam. The next week, our colleagues in the join here. What are your final words here?
Okay. It's my final words. They say. Actually, for me, I lost hope in them long time. But right now, all that is going on. The Supreme Court, I can say about 80% of the citizenry in Ghana doesn't have any hope in the Supreme Court again.
And that is a very bad thing.
In all other, because it is now becoming clear. Say, any case here on the record court, once it is government affiliated, you can predict the outcome. The verdict is there. You can predict it, and it is going to be like that. What they are saying, and they don't care giving us anybody because provided they said they think they favor the government. They don't care what they are saying because if you look at the verdict here of the in fact, it doesn't make sense because in some of they have a particular agenda, and it is because of that agenda they are supposed to give us that verdict. So whether we like it or not, we have to accept it. And every Tom, Dick, and Harry in the country can read meaning into it, like I'm saying. What they are saying. When you say you law school and they are interpreting this very cool to understand.
Over.
Because in some way, yeah. In fact, gradually, Abacha, our Supreme Court is becoming a place that people don't have trust anymore. They don't trust
that is very unfortunate, but all the same. Yeah. Let's call it a night. Thank you very much for your time. See you next week, boss.
Okay. Bye.
These are called the good old days when the morale was so high. And then they offer me money a short bar. Right now, class, I need a program. They try say an hour between they discuss 3 issues. With all panel members and on be issued in a better time of 5 minutes. We are straightly on point. That's it. Sometimes I ask myself, how's it been to show for almost 2 to 4 hours? What they excluding commercials anyway, and there's no time. But I said no, the TP and canasities cannot because some people just spend time to get the actual issue. How can I say no? Let me wrap up on this issue. All right. In short, issues I need to discuss here was ruling be a free Supreme Court a baby a divided public somehow, but we didn't say it was too sharp. But maybe person busy on how the inconsistency of the court based on their previous ruling. Now almost how much said this is also politically motivated. But one thing I asked everybody and said, what is so be no matter will be past issue being a one part considering the present situation here. I think the defendants, lawyers, they did very well. Almost capitalized on a gray area, as I stated earlier, and almost present the case into Supreme Court. Says a law be anywhere else stop a deputy from doing so there. Then the person is entitled to vote. And it's automatically if you're entitled to vote in Parliament, therefore you should be part of quorum formation. Simplicity. Another issue I'm raising was about jurisdiction. Yeah, I explained it because the court did not seek to adjudicate policy issue, but what the court sought to do was to address the legal issues surrounding the policy issue. That's 2 different things. Another issue that also came up was about jurisdiction, whether the court will have power to hear the case or not. I've explained that. Said because it's the apex court in our country. It is the highest court in Ghana, therefore they have the jurisdiction. And moreover, the issue, even appeals court can't address this issue. When anytime it comes to constitutional interpretation, you go to the highest court. And clearly that's what Ghana Supreme Court did. You see, let us all accept this. So share plenty from lawyer and the I say nobody has won or no one wins. It's the Republic that has actually won. So let's go by that. Now you're moving forward. I've seen some of the reactions every opposition or at the bar NDC for minority. They are not using any law to challenge the Supreme Court, either 102, 104, or the standing order 109. But what they've sought to do is how the nature or how bad the E-Levy is, no more capitalize on it to override the logical or the legal reasoning, which is unacceptable. We had the former president, Sir John Dramani Mahama, who issued a statement and say it's even absurdity. Harry Idrisu Super said, Supreme Court for not supported this. I don't think says a make a policy decision now. Almost support E-Levy. It could be that they don't support the E-Levy, but when the issue appeared before them, they have to look at the legal aspect to address the law. And that's what the court actually sought to do. On this note, you know, if I can't wait so, nah, Madam BBS. Thank you very much for your time. See you same time. And not forgetting tomorrow, the Spiritual World Show. Very interesting topic, BSc.